Welcome to today's webinar, The American Court System, brought to you by NCSL. It is now my pleasure to turn the floor over to Kay Warnock. The floor is yours.
Hello, everyone. This webinar is sponsored by the Research, Editorial, Legal, and Committee Staff Association and is supported by an NCSL e-learning grant. Over 180 registrants from 42 states are participating today. Participants include legislative staff, cities, counties, and others working with state and local government. This webinar is being recorded and will be posted on the NCSL website for the use of those unable to attend. If you need a copy of the slides, you can click on the media library icon, which is the little arrow at the top of your screen, and download the presentation. The presentation is also going to be linked from the webinar's homepage after the presentation. If you have any questions during the webinar, please feel free to type those in the chat box, and Lisa will answer those questions at the end of the presentation. Our speaker today is Lisa Soranen. She is the Executive Director of the State and Local Legal Center. Welcome, Lisa.
Thank you, Kay, and thank you for inviting me to speak at this session. So, as he mentioned, I'm going to be talking about the American court system. And some of you who are non-lawyers may feel that you should already know all this stuff and that you shouldn't have to learn it from a webinar. But in truth, the information I'm going to present today is largely sort of not known by the public at large. When I went to law school at the University of Wisconsin-Madison, before school began, we were given a book. It was a thin book where we had to learn basically about the concepts that I'm going to talk about in today's presentation, all of which leads me to the conclusion that a lot of these things are just sort of not commonly known out in the world. And if you're a lawyer listening to this presentation thinking, gee, I should know all this stuff, I went to law school, I've done some version of this presentation now 3 times. And when I first put it together, I had to go and find one of those little books that sort of defined how the courts worked, just to give myself a framework for the conversation, because this isn't stuff that I talk about every day. I also must admit that this presentation is a bit Supreme Court heavy. Probably I focus half the time on other things and half the time on the Supreme Court. Part of this is because I work mostly with the Supreme Court, so I just have a bias in that direction. But the other reason is that unless you're doing something very, very niche-y, if you're going to be dealing with court cases, probably most of the time you'll be dealing with the Supreme Court because there are so many lower court cases all the time, it's hard to follow them. But with that introduction, I will begin. So I'm going to talk about the American legal system, give an overview. I'm going to talk about the Supreme Court. I'm going to talk about the impact of amicus briefs, because that's part of the work that I do, and then talk about some miscellaneous information. So to learn more, I recommend this book by Tony Fine called The American Legal System, A Resource and Reference Guide. And you can find Chapter 1 free online, and it just overviews a lot of the stuff that this presentation covers. So basically, in the United States, we have a dual court system. Those are 2 court systems that operate next to each other simultaneous. And that's the federal system and the state court system. So if you pull out your pocket constitution, you can read Article 3, which talks more about the power of the federal courts. So federal courts decide just a limited subset of cases. They decide cases involving federal constitutional issues, federal statutory issues, diversity cases where parties are from different states and the amount of money is $75,000 or more. If the United States is a party, the federal courts have jurisdiction. They also cover a couple of special topics like admiralty law, antitrust law, maritime law, and in some instances cases can be removed to federal court. So what do state courts decide? Well, they decide any other case, including cases where the federal courts have jurisdiction with a few exceptions. So here's a little more about the court structure. And it's somewhat similar for both federal courts and state courts. So both court systems have a lower court. This is usually the trial court or the fact-finding court. The next level is the intermediate court, which hears appeals from the lower court. And then there's a high court, and this hears appeals from the immediate court. So generally, if you're going to bring a case, you want to bring it at the lowest level of of a court. So you'd start out with your case in front of a trial judge in most instances. There are some exceptions. There was a case decided by the Supreme Court this term involving the Clean Water Act, and the Clean Water Act has 7 exceptions where if you have a challenge under these particular sections of the Clean Water Act, you start in an appellate court rather than in a trial court. But in general, you're going to bring your case at the lowest point possible. So now a little bit more on the federal court system. So in terms of lower courts, there are 94 in the United States, which is about 2,700 judges. So I'll use my home state, Wisconsin, as an example. There are 2 federal district courts in Wisconsin, the Eastern District of Wisconsin and the Western District of Wisconsin. The intermediate court in the federal system is called the Court of Appeals, or the U.S. Court of Appeals, or they're called like the First Circuit, the Second Circuit, the Third Circuit, the Fourth Circuit, etc. So there's 13 of these intermediate U.S. courts of appeals. Wisconsin, my home state, is in the 7th Circuit, along with Indiana and Illinois. Then, of course, there is the High Court. The highest court for the federal system is the Supreme Court, which has just 9 justices as compared to the lower courts, which have tremendously more judges. So I try to have one graphic in each presentation, and I didn't want to disappoint you guys. So here you can see a map of the federal courts of appeals. You'll notice on the left-hand side of your screen that the 9th Circuit covers a lot of states. Even if you don't spend a lot of time with the courts, the 9th Circuit is probably the court you hear the most about. They tend to have the most liberal justices, the most overturned by the Supreme Court, and they're just kind of a renegade district. There's been talk over the years of dividing the 9th Circuit, but that's sort of beyond the scope of this presentation. So many of you have probably heard of the D.C. Circuit Court of Appeals. It's one of the 13 federal circuits along with the 1st, 2nd, 3rd, etc. But it's a very, very small court because it just covers the District of Columbia. But why it's so prominent is that it has special jurisdiction over the federal agencies. So it hears a lot of cases involving things like the Clean Water Act and other things that would come out of Washington, D.C. And it's not unusual for Supreme Court justices to have started in the D.C. Circuit. Justice Scalia, off the top of my head, was a judge there at one point in his career. There's also a number of specialized federal courts that just hear certain kinds of cases. The U.S. Court of Appeals for Armed Services, I'll just pull that one out. If you look at President Trump's list of potential Supreme Court nominees, he has someone, a female, I can't think of her name off the top of my head, who is a judge on that court. Probably the most commonly heard of court on this list is the Federal Circuit. It hears a number of cases based simply on subject matter, most notably patent cases, so not cases that affect state and local government very often. But it kind of makes sense in our court system to have courts that just focus on niche topics like bankruptcy, so that judges don't have to learn every single thing, especially when an area of law like patents or bankruptcy or military is very, very specific. So the state court structure, the structure of the state court is quite similar to the structure of the federal court. And I use Wisconsin again as an example. The lower court are called circuit courts, which can be kind of tricky because that also is a term that's used to talk about courts of appeals for the federal system. But the trial courts in a lot of states are called circuit courts. They're usually organized by county. The intermediate court in Wisconsin is called the Wisconsin Court of Appeals. Not all states have intermediate court of appeals. South Dakota, for example, doesn't. And they might go by different names as well. But in Wisconsin, the intermediate court is the Wisconsin Court of Appeals, and there are actually 4 courts organized by district. And the high court is the Wisconsin Supreme Court. Like the federal system, there are specialized courts at the trial level in the state court system too. Probate court is a special court, family court is a special court, juvenile court, things like that, again, that are sort of niche-y. So what do courts decide? What do they do? Well, they decide what are called live cases or controversies, and they issue opinions. So that's the primary function of courts. So there are a couple of doctrine that define instances when courts don't get involved. So I'll talk about a couple of these. So standing is, to have standing in a case, you have to have a direct interest or a dog in the fight, if you will. Sometimes courts will say that a person doesn't have standing. Probably the most famous example that I can think of sort of recent years was there was a father who was challenging some of the language about God and the Pledge of Allegiance. And the parents had joint custody, but per their joint custody agreement, the mom had like 51% custody. And so ultimately she got to decide, what religious matters their child was going to deal with, if it came to blows, if you will. She had no problem with her son saying the Pledge of Allegiance with the language of God. So the court said, there's no standing for the father because he has no say-so over what happens in regard to his son saying the Pledge of Allegiance. So that's one example. Another sort of interesting example is political questions. There's some things that the court says that the court just shouldn't get involved in. It has too much to do with politics rather than with law. Probably the most famous example of this, and the court sort of abandoned this doctrine, is Baker versus Carr, where the court said it would get involved in redistricting cases. Mootness is when a controversy has been resolved by the passage of time. Just to give you an example, there was a couple of cases a few terms ago involving a transgender student who wanted to use a particular bathroom. At some point, that transgender student graduated from high school and is no longer going to need to use that bathroom. So that case will probably be moot. So there's a couple of other doctrines that are sort of like parachutes for the court, where if it doesn't want to decide a case, it can turn to those doctrines, and sometimes the doctrines are just so obviously there that the court is forced to rely on them. But courts don't decide cases when these issues arise. So if you're not a lawyer, you may not have ever read a Supreme Court opinion or even a judicial opinion at all. And if you ask me for one, if I had to recommend just one opinion to read, I would recommend the Riley versus California opinion. The issue in the case was whether police officers need a warrant to search a cell phone of someone when they're arrested. And the alternative to having a warrant would be, of course, having no warrant, but having, reasonable suspicion or probable cause or something like that. Justice Roberts wrote the opinion. It's very, very beautifully written. It's very simple, and it's not very long. Adam Liptak of the New York Times used to say the Supreme Court has three good writers: Justice Roberts, Justice Kagan, and Justice Scalia. Justice Scalia is, of course, no longer with us, but it still has two very good writers. And this opinion I found in particular just showed Justice Roberts' ability to sort of write for anyone in a case that anyone could possibly be interested in. So how do courts decide cases? Well, they're supposed to rely on the law, right? And much of the law is precedent. So what is a precedent? A precedent is a previous opinion. So the United States has what we call a common law system. And this system has English roots, and it's a system of judge-made law, where a court decides a case by looking at, well, what did court say in the past about a similar issue or the same issue? Most of the time it's a similar issue. This system can be opposed to like the French system, which is a system of codes, where if you need an answer, you go and look at the code. We have codes in the United States, but we don't rely on them as heavily as we rely on case law, which is this precedent and judge-made opinion. So there's different kinds of, in different cases, case law has different sort of relevance and importance. So some cases involve pure questions of case law. There are going to be no statutes. There are going to be no executive orders. There are going to be no administrative agency regulations. These are kind of the laws that we pass along since our roots in England, if you will. Tort claims, property claims. The first case I ever worked on when I was a clerk in Wisconsin involved a police officer shooting a dog. And the question was whether or not the person should get emotional distress damages. Well, there's no statute covering this. So the court looked at, well, what was the precedent on when people get emotional distress damages? Is it for things like dogs, or is it for other things? Another sort of perennial issues: who gets the wedding ring or the engagement ring when a wedding is called off? Again, there's not likely to be a statute on that, but different states will have judge-made law on that sort of topic. Sometimes the court is dealing with a statutory provision, but to answer the question, they can't just merely look at the statute and have a very clear answer. So we'll look to case law to sort of figure out what the answer should be, even when there's a statute that's relevant. So to give you an example, many of you may be aware of the fact that a number of courts have held recently that you can sue your employer for sexual orientation discrimination against under Title VII. This is a new thing. Title VII has been around since the 60s or 70s, but only recently has a court said that you can sue on the basis of sexual orientation versus gender, sex, national origin, race, and other things that have been classically covered. How did the court come to this conclusion? Well, they looked at case law in other areas, for example, like the same-sex marriage decision. And then even when there's constitutional issues, maybe especially when there's constitutional issues, the court is going to look at case law. Because remember, the Constitution, like if you really are carrying your pocket Constitution, I mean, it's as light as a feather. So the only way to know what the Constitution means is to sort of look at past precedent and extrapolate from that. So that's one place in particular where judges and courts rely heavily on case law and past precedent. So what is the law sort of more generally? Well, ironically, common law and case law are at the bottom, in theory, of like the importance of law, but most cases don't involve constitutional issues, which is why case law is so important in our system. So in terms of law, this is our law, the American law, in the order of importance. Of course, first the U.S. Constitution, then the statutes, which are passed by Congress, agency regulations, executive orders, and then case law or common law. So that's the order of importance of the law, if you will. So where does it come from? The Constitution, of course, comes from our founding fathers. Statutes come from the legislature. Rules and regulations come from administrative agencies. Executive orders come from the president or the governor. And case law or common law comes from judges. So how does the law develop? Well, as I was explaining, it develops over time through precedent. And there's rules for how precedent works. So in particular, if courts at the same level have to come to the same conclusion. And actually, more technically, courts in the same jurisdiction at the same level have to come to the same conclusions. So in other words, like the Wisconsin Supreme Court shouldn't be overruling itself all the time. And the Wisconsin Court of Appeals, which is underneath the Wisconsin Supreme Court, has to follow the rules of the Wisconsin Supreme Court. Now, the one court that everyone has to follow is the United States Supreme Court. To give you another example, like the 7th Circuit doesn't have to follow the 9th Circuit, and the 9th Circuit doesn't have to follow the 6th Circuit, but all the district courts in the 7th Circuit have to follow 7th Circuit law. And all the district courts in California, for example, have to follow 9th Circuit law. So that can get a little tricky unless you can keep all your courts straight, but that's generally sort of how it works. So there's a very important concept in case law, and it's called stare decisis. And in English, that translates to let it stand. And what stare decisis means basically is that precedent should only rarely be overturned. And so why do you have a system based on stare decisis? Well, if you have judges overturning each other right and left, that wouldn't be a very predictable system, and it wouldn't be very fair to the parties, who might be able to avoid litigation by just looking at what the judges had decided before. And the other thing is that it prevents judges from being arbitrary. So that's the reason why we have stare decisis, and why, in general, courts follow the same rules that they followed before. So the Supreme Court does occasionally abandon precedent. And they have a bunch of rules for when they do it. And basically, if precedent has really gone out of style, if it's really old-fashioned, if it's been criticized a lot, if there have been other relevant changes in the legal doctrine, or there have been changes in the relevant facts and circumstances, the court is inclined to overrule precedent. With that being said, the Roberts Court is famous for not overruling precedent. There was an article in the New York Times a couple of years ago where the court was supposed to overturn like 6 or 7 or maybe even 8 cases, and it didn't overturn any of them. What the court might do is sort of narrow a precedent, or indicate that a precedent shouldn't be expanded. The last time I can think of the United States Supreme Court overturning a precedent was in Citizens United. I'm quite certain I'm wrong about that because Citizens United was almost 8 years ago. And probably they've overturned a precedent since then, but that's the only one that I can think of off the top of my head. Just to give you a quick example of a good case where they might overturn a precedent is, this term the court is considering South Dakota versus Wayfair, where the court had previously ruled that if you didn't have physical presence in a state and you were a retailer, a state couldn't force you to collect online sales tax. And this might have made a lot of sense, in 1992 and in 1967 when the rule was adopted, when you didn't have online vendors who don't have a physical presence in another state selling a lot of goods. So we're kind of expecting the court to overturn that precedent, but it's a rare thing when it happens. There's also union dues case this term where we expect the Supreme Court to overturn precedent. So that side covers all of that. So what if a precedent isn't a perfect fit? Well, this happens all the time. For example, when the Supreme Court was recognizing the right to same-sex marriage under the Constitution. Of course, there was no case that said there was that right, otherwise the court wouldn't have been deciding the issue. But the court had gone through a process. First, it had decriminalized sodomy. Then it had said that the Defense of Marriage Act wasn't constitutional. And then it moved from there to a constitutional right to same-sex marriage. So if precedent isn't a perfect fit, the courts are going to look and see, well, what precedent do we have that's sort of similar? And what court does it come from? Does it come from a court that's very prestigious? Are the facts similar from that case to this case, even if they are identical? How old is the precedent? How strong does the reasoning seem to be? So those are the factors that the court will look at when there isn't precedent and it's trying to decide what to do in light of that. Okay, so when the court deals with statutes, it has a lot of special rules. Justice Scalia probably made famous more than anyone else the idea that statutes should be read for their plain meaning. That in general, you should be able to sit down and read a statute and know what it means. In reality, it's almost always a little bit more difficult than that. So what if a statute is ambiguous? Well, there's a number of tools that the courts look at to determine how to interpret the statute. Some of these tools are looking at the statute as a whole, like what does it seem to mean when you read it in total, looking at the context of the statute. And then there's a bunch of what are called canons of statutory interpretation, like looking at does the statute use the word may or does it use shall? What is the punctuation? What's the dictionary definition of a term? And another thing is legislative history. That said, the Supreme Court has sort of frowned on legislative history. Justice Scalia was not a big fan of it, but maybe about 2 weeks ago, Linda Greenhouse had written an article in the New York Times talking about how the court more recently has been more favorable towards legislative history, but it's not considered the best evidence of congressional intent. So the presidential power. The president basically has a couple of tools to sort of meet his or her agenda. One of them is through issuing regulations. Another one is other agency guidance, which I'm not going to talk about at length. And the final one is executive orders. When I first did this presentation a couple of years ago, I didn't even talk about executive orders, but they've gotten to be such a big deal that I've now included them in my presentation. But I'm going to first start talking about administrative agencies. So for those of you who took this class in law school, you learned that this is a fourth branch of government. And agencies, of course, issue regulations that interpret statute and other guidance. The advantage of relying on agencies is that they have technical expertise. The disadvantage of relying on them is that they're not politically elected and they might be they're not elected and they might be politically motivated. Regulations, though, formal regulations, go through a lengthy notice and comment process, so in theory, the agencies can't just do whatever they want. It's not easy to get rid of regulations. Again, if an administration wants to do this, they want to get rid of an old rule from a previous administration, again, it has to go through a lengthy notice and comment procedure. The Wires of the United States regulation is a great example. President Trump wants to get rid of these regulations. My guess is if he's able to do it, it's going to result in lawsuits no matter what, but it will take him probably all 4 years of his first term to do this because it's just such a long and complicated process. So importantly, courts generally defer to agencies' regulations when an agency is interpreting a statute per a case called Chevron versus NRDC. But Chevron deference, as it's called, is only applied to regulations if the statute is unclear and if the agency gives a reasonable interpretation to the statute. So the Supreme Court in recent years has been quite critical of federal agency deference. And one of the doctrines in particular that's been, or might be in trouble, is the Auer deference. This is where courts defer to an agency's interpretation of its own regulation. So courts don't like agency deference because it basically takes authority away from them. Interestingly, Justice Gorsuch is not a big fan of Chevron deference, but for now, Chevron deference is still alive and well. So executive orders. Like I said, it's not something I even talked about a couple years ago, but not something I feel like I've got to give a fair amount of attention to. So executive orders are issued by the President, and they're supposed to direct the work of federal agencies and implement authority granted to the President by federal statute or the U.S. Constitution. Now, what's interesting about executive orders is this. There's no provision in the Constitution that explicitly authorizes them. But every president except one, since George Washington, has issued them. And both President Obama and President Trump have tried to accomplish a lot through executive orders. The problem with executive orders from the perspective of a president is that they can be easily reversed by the next president. There's no notice and comment, you just get rid of them. They also can't be used to overturn laws issued by Congress. And an example of a case where the President Truman tried to, by executive order, do something that he just didn't have the authority to do. So just to give you a sense of the fact that it's been both President Obama and President Trump who've done a lot of really big things by regulation and by executive order and by other agency guidance like letters. You can see on the screen, this are some of the things that President Obama has done. And here are some of the things that President Trump has done. Most significantly, what President Trump has tried to do is not just have his own executive orders or his own regulations, but roll back those of the Obama administration. So executive orders are a big part of the American landscape. So now, at this point, right about halfway through our presentation, I'm going to talk more about the United States Supreme Court. So why is the Supreme Court important? Well, it has the last word on interpreting the U.S. Constitution. And unless, of course, the court reverses itself, which sometimes it does, Citizens United is an example. And also, like in theory, the Constitution can be amended, but of course it hasn't been amended in a long time, and it's really difficult to do this. And then, as I said before, the lower courts in all 50 states have to follow its rulings. Now, the Supreme Court is not always so supreme. It can be, if the Supreme Court interprets a statute and Congress does not like the interpretation, all Congress has to do is change the interpretation. It's as simple as that. Some of you remember right before President Bush left office, the Americans with Disabilities Act Amendment Act. The Supreme Court had issued a number of decisions under the ADA, very much limiting it, and Congress said that's not what they meant by the ADA, and they changed it. So sort of famously, the first law that President Obama signed when he was president was the Lilly Ledbetter Fair Pay Act. That reversed a case involving a woman named Lilly Ledbetter. I don't remember if it somehow involved her pay. I don't remember if it was under Title VII or it was under one of the federal laws. So Congress, especially when it's been more active, sometimes over the years has done a lot to redo the work of the Supreme Court. But I always find it intriguing when people are like, why doesn't the Congress fix Citizens United? Well, the reason is because Citizens United is an interpretation of the Constitution. And the only way to change an interpretation of the Constitution is to actually amend the Constitution or wait for the Supreme Court to change its mind. There really isn't much that Congress can do about Citizens United. Another thing I always find kind of interesting is people talk about Second Amendment rights as if we all sort of agree as to what they are. The truth is it's the Supreme Court that has the final say on what the Second Amendment means, and all they have said is that Americans have a right to a gun in their home for lawful purposes, and that's it. So, again, off my soapbox onto other topics about the Supreme Court. So why is the court so powerful? Well, there's only 9 people. They're not elected. They're appointed for life. They're somewhat homogeneous. They are never average and never young. They decide many of the most important issues of the day, and like I said, they're the final arbiters of constitutional matters, and they get to pick and choose what they decide, which gives them some power. So what is the role of the Supreme Court? Well, Article 3 says very little about the Supreme Court other than it exists and that it has jurisdiction to decide particular cases. So sometimes the court has original jurisdiction. Sometimes you see these water cases between 2 states. There was one just decided a few weeks ago, maybe involving Arizona and Colorado. Some of the original jurisdiction cases can be brought in the Supreme Court directly. Other cases involving ambassadors, I can't imagine how often those happen. The court will also hear cases where state courts have decided a federal question, and they will hear cases from the federal appellate court and sometimes even from the federal district courts, but that's very, very rare. So as a practical matter, the Supreme Court has defined its own role. I mean, the Constitution really doesn't say, so it's had to kind of figure it out. So Marbury versus Madison, I read that in law school, and I couldn't figure out what in the world the court was trying to say. But what it was trying to say is it confirmed what we call judicial review, which is the idea that the Supreme Court can declare statutes unconstitutional. I guess this was not the case in England. I just learned that recently. So this was a big deal, and it wasn't something that was made obvious to the founders. But in Marbury versus Madison, that's what the court said it's going to do. It was going to declare laws unconstitutional when it felt like it, and no one's really stopped it. So there we have that. So the court has defined its own job through its rules because, like I said, it's not otherwise defined. The court says this is what we do. We basically resolve circuit splits. That means when you have 2 federal courts of appeals, or 3 or 4 or 5, that have decided an issue, big or small, in different manners, the Supreme Court often gets involved. I would say in 70 to 80% of the Supreme Court cases, there is a circuit split. The other thing is the court decides important questions of federal law. Anytime a federal statute is declared unconstitutional, doesn't matter whether or not another court has ruled that way or not, the Supreme Court is likely to get involved. But it's important to remember that the Supreme Court will only hear a case if someone brings a petition to it. The Supreme Court does not spontaneously decide to hear cases. So how would you get a case to the Supreme Court? Well, you file a petition in the court if you lose below. And the reality is that the Supreme Court will say it's not an error-correcting court, meaning that if the lower court just decides something wrong, it won't get involved. It really resolves circuit splits. But with that said, 80% of the time the Supreme Court reverses the decision below, which sometimes just means that it's picking one side of the circuit split, and it's not picking the side of the case that it granted in. So if the Supreme Court hears a petition in the case you've been involved in it and you won below, that is not good for you. So you can't go to the Supreme Court right away. You have to generally file your case at the lowest level possible, this is a trial court, and move it up through the courts. In general, it takes about 10 years from the incident happening to a case to get before the Supreme Court. But there are some sort of interesting exceptions of cases that have moved really quickly. The same-sex marriage cases moved really, really quickly. I think that's because so many of them were brought in federal circuits, and it didn't take that long for the courts to have conflicts. And the court really didn't take one of those cases until the circuit courts were in conflict. Most recently, you might remember there was a recent challenge to DACA, and federal district court, so lowest level trial court in the federal system, said DACA cannot be gotten rid of the way the president did it. So in that instance, the Trump administration appealed right away to the Supreme Court, which is kind of crazy because this is just one judge issuing a preliminary opinion. And the Supreme Court said, no, we're not going to take that case. They didn't say why, but probably because it hadn't gone to the normal chain of command. Cases don't get to the Supreme Court immediately is what I'm just trying to say. So the Supreme Court review is discretionary. It takes 4 justices to hear a case. And they can accept or deny a petition for any reason or no reason at all. Oftentimes, they wait for a circuit split. Same-sex marriage is a great example. They didn't take a case until they had a split. And sometimes they don't wait at all. And when the ACA was declared unconstitutional, they got involved right away. I guess at any time a federal statute is declared unconstitutional, the court's going to be there. So the court's receiving between 7,000 and 8,000 petitions a year, and it's only deciding about 70 of those cases. A lot of those petitions come from prisoners. A lot of them have no chance of being granted at all. But it's still fairly difficult, even with a really good case, with a circuit split, for the court to take your case. So many of you have a background you come from a state background. You work for a state legislature, you work for a state agency. The Supreme Court's impact on states is hard to understate. It's hard to overstate. About 2/3 of the Supreme Court's docket affects states in some way. If you look back at the last 5 or 6 years, almost every single blockbuster case that the Supreme Court was hearing somehow involved the states. Back in the day when the court was deciding all these Guantanamo Bay cases, states were, they weren't as prominently featured in the Supreme Court. But nowadays, if it's a big case, it's got impact for the states. And there's no limit to the issues that the Supreme Court will take that affect states. Takings, Fourth Amendment searches, First Amendment free speech, tribal issues, public employment, qualified immunity. There's no limit. So what does the docket really look like? Most people think about the Supreme Court and know about the Supreme Court at the end of June. What happens at the end of June? About half of the court's opinions are released in June, and almost all of the opinions in the big cases come out in the last 2 weeks of June. So that's when people hear about the court. The reason why they don't hear about the court otherwise is because they deal with really, really boring issues. Gates versus the United States. Is a fish a tangible object for purposes of a provision in the Sarbanes-Oxley Act titled Destruction or Removal of Property to Prevent Seizure? These are the kind of cases that the Supreme Court is hearing most of the time. They're not really all that sort of glamorous. So green light or red light? Why would the Supreme Court want to decide an important issue right away? Or why would it want to wait? The Supreme Court actually has a lot of power by doing sort of nothing at all. I'll give you an example. Example is guns. One of the questions that people ask me the most frequently is, when is the Supreme Court going to do anything about guns? And my answer is, they're actually doing a ton about guns. You just don't realize what they're doing. What they're doing is they're refusing to hear lower court cases when the lower courts have upheld restrictions to gun regulations. So just to mention again, in 2005, in the case of D.C. versus Heller, the Supreme Court said that people have a Second Amendment right to a gun in their home for lawful purposes. And the following information that I have on the next slides comes from the Gifford Law Center. So in the last 9 years, the Supreme Court has rejected 82 cases, refused to hear 82 cases that expanded gun rights beyond I guess you would say really limited gun rights and expanded D.C. versus Heller. I guess it depends on how you want to say that. So to put this more in perspective, since 2008, over 1,230 cases have been brought challenging state and local laws that, state and local gun control laws that limit the use, possession of guns. And courts, lower courts, at a rate of 93% have upheld these restrictions on access to guns and use of guns. And what the Supreme Court has done is it has basically remained silent. It has been asked 82 times, like I said, 82 times in about 13 years to review a law that limits people's access to guns. And every single time it has said no. And here's a list of all the kinds of laws the Supreme Court has refused to hear. So why won't they take the case? This is just my opinion, but I'll express it for what it's worth. So it takes 4 votes to grant a petition, right? And I think there's probably 5 justices on the Supreme Court that think gun rights should be very broad. The Second Amendment should be interpreted as broadly as possible. And there's 5 justices that believe that as a legal matter. I think as a practical matter, Justice Roberts and Justice Kennedy have serious questions about whether that's really in the best interest of our country. Having no gun control at all, is that really in the best interest of our country? I think, like I said, there's two justices that maybe believe legally speaking that's how it should be, but aren't for sure practically speaking. And as a result, what they've done is just stayed silent. And they've allowed these lower courts to uphold restriction after restriction after restriction. So here's a little bit more on our Supreme Court. So in general, we're considered to have a 5-4 court made up of conservative justices and liberal justices. The star next to Justice Kennedy indicates that he's considered a conservative justice or a swing justice who leans conservative. The perception is that it's a 5-4 court with Justice Kennedy in the middle, and that really is only an accurate perception for the big cases. In the big cases, that's usually how the court comes down. And more recently, Justice Kennedy has joined the liberals in some of these big cases, taking more liberal position on some social issues. But in the sort of run-of-the-mind cases, the court is much more unanimous than you might think. About 45% of Supreme Court cases are actually 9-0. Only 20% are 5-4. And about 60% over the last 10 years have had conservative outcomes, which should make sense as we have a Justice Kennedy who sort of leans to the right. About the justices generally, so all of them, every single last one of them went to Harvard or Yale. They're all Catholic or Jewish. Justice Gorsuch might be Episcopalian. It's sort of hard to say. Most have worked for the federal government at some point. They happen to have that bias. Most were lower court justices. And the age range now goes from 50, Gorsuch, to Ginsburg, 85. I do believe she had a birthday last week. So why do we have 9 justices? The Constitution is actually silent about the number, but there was a law passed in 1869 that fixed the number at 9, and it hasn't been changed. Some of you may be familiar with the expression, a switch in time saves 9. So in the 30s, President Delano Roosevelt was pushing all this legislation to Congress, and the Supreme Court kept on declaring it unconstitutional. And he basically said, if you keep that up, I'm going to pack the court. I'm going to fill it with all my buddies, and they're going to rule the way that I want to. So a switch in time saves 9 refers to one or more of the justices sort of taking the hint and voting to uphold these laws that the court had previously been declaring unconstitutional. So you might wonder, can I be a judge, or better yet, a Supreme Court justice? And the answer is there are actually no qualifications. But the President has to nominate you, and the Senate has to confirm you now by a majority vote. And the great thing about this job is you are appointed for life. When it comes to state court judges, the practices vary significantly between appointment and election. So our latest justice is, of course, Justice Gorsuch. He has ended up being a real coup, I think, for President Trump. For the longest time, I had to say he was President Trump's biggest accomplishment. But at this point, it's probably fair to say that the tax bill, though maybe you should give more Congress the credit, is his biggest accomplishment. But he remains, I would say, President Trump's first or second greatest accomplishment. He's got impeccable credentials, he's young, and he's already proved himself to be a reliable conservative. The thing that I find most interesting about Justice Gorsuch is this. A President Cruz, a President Kasich, a President Rubio could have picked him. Unlike a lot of President Trump's choices, he doesn't really reflect President Trump's idiosyncrasies, in my opinion. So it is possible, even if President Trump is just a one-term president, that he could have a second, third, or fourth nominee. The average age to retire, this is, I think, since the 50s, is 79. And we have 3 justices who are at or over that number. 2 of them are liberals, and 1 of them is a moderate, Justice Kennedy. And remember, we had a really big change when Justice Gorsuch was nominated. As a practical matter before, to get someone through the Senate, you had to have 60 votes, which meant to somebody you had to have bipartisan agreement on that person. Now you just need 51 votes. So as a practical matter, if there are 51 Democrats in the Senate in 2018, they could limit President Trump's choices of a nominee. So only time will tell what will happen in that regard. The Supreme Court schedule is not unimportant. I mean, this might seem like a sort of random detail, but the court does not operate all the time, and it operates in a very planned out way. So the term runs from the first Monday in October until June 30th. So the Supreme Court has a very long summer recess. The court hears oral argument from October until April. It issues decisions from about December to June. And as I said before, you're not going to hear about the Supreme Court until June because most of the time it's just sort of not covered. If you have an interest in the Supreme Court or you want to learn more about the current docket, I highly recommend the blog called SCOTUS blog. It's not an official blog of the Supreme Court, but it's absolutely the best resource on the Supreme Court. It summarizes every case before and after oral argument. It's written for non-lawyers, and there's also symposiums where people write on particular topics. And if there's opinion days, there's a live blog. So if you're a real Supreme Court junkie, this is a place where you absolutely have to go. If you read a lot of the stuff that I write, or you read stuff in advocacy organizations like mine, all you're going to hear about is amicus briefs. So I'm going to talk a little bit about those. So how do judges decide cases? We have to take a step back first. Well, at the trial court, they're typically deciding cases based on written legal briefs and sometimes amicus briefs. And so the merits briefs are the briefs that are written by the parties. So if you're a party to the case, of course you get to write a brief. And in that brief, you're going to focus heavily on the law, because the law is presumably what's going to help you win. The court also will look at oral argument to decide cases and independent research and clerk research. And then amicus briefs, which I'll talk about in a little bit. So judges also typically have perspectives, and these perspectives will inform them in how they decide cases. So you often hear the idea that a judge is a conservative or a liberal. So that kind of roughly translates to Democrat or Republican. But there's another way of looking at judges too, and that's judicial philosophy. So there's a number of judicial philosophies. One of them is judicial activism versus judicial restraint. That's the idea, like, should judges be more involved in cases or less involved? Should they be more involved in issues? Should they be less involved? And that, again, sort of correlates with judicial activism, liberal, judicial restraint, conservative. Not perfectly. Loose constructionist, strict constructionist. So when you're looking at the language of the statute, how literal do you feel you have to be about what's written? Judges have different views on that. Living document original intent. This is very important. Some people believe, Justice Scalia was sort of the godfather of this, that the Constitution, for example, was sort of frozen in time, and whatever our forefathers wanted the Constitution to mean, it should mean today as it meant, 400 years ago. There are other people that say, no, the Constitution is a living document. It changes over time. It needs to adapt with the circumstances of our time. The living document, that tends to be a more liberal approach. The original meaning tends to be a more conservative approach. Then, the law school I went to, Wisconsin, was legal realism. That philosophy is that words don't matter, precedent doesn't matter, nothing matters. The only thing that matters is what judges want. Judges will simply get the outcome they want using any of the tools in their toolbox. Some people call legal realism very cynical. For me, because it was the philosophy of my school and what I heard over and over again, I never quite had that judgment towards it, but I don't think it's an unfair view either. Okay, so now back to amicus briefs. So amicus briefs are submitted by non-parties in cases, and they represent or they discuss the interests of the members that the amicus brief is filed on behalf of. So when the State Local Legal Center files amicus briefs on behalf of NCSL, we're representing the views of state legislatures in our briefs. So what we do in these briefs is typically to make policy arguments, not legal arguments, and we explain how a ruling one way or the other will affect all of the members of our group. So in theory, courts are supposed to ignore amicus briefs because remember, they're supposed to be deciding cases on the basis of the law. They're not supposed to be deciding on, who might be affected or whose feelings might be hurt or something like that. But the reality is that amicus briefs do matter. The court, particularly the Supreme Court, cares deeply about the practical implications of a case. They don't want to be embarrassed by doing something that just kind of doesn't make any sense, but made sense per legal arguments. And also, as another practical matter, the lawyers in these cases who argue on the merits positions, their interest is to win for their client. They're not trying to win for every city or every state. And an amicus brief has a unique ability to speak for everyone as they are able. And at this point in the game, if there's Supreme Court litigation, both sides have amicus support. So you just kind of have to be there. So State and Local Legal Center is the voice of state and local government before the Supreme Court. We're filing typically 10 to 12 amicus briefs per term. This one we filed 13, which is pretty high. It's just a really active and interesting Supreme Court term, and I received funding from all of the big seven. So the Supreme Court frequently notices the work of the State and Local Legal Center, which I'm very proud of. So you can't answer this. You can only answer it silently. But I want y'all to guess what justice is most likely to cite SLLC amicus briefs. It's probably not who you think. It's actually Justice Ginsburg. And obviously, I'm not expecting you all to read this slide, but very recently the Supreme Court issued an opinion where Justice Gorsuch cited generously to State and Local Legal Center amicus briefs. The issue was so narrow. It was on statute of limitations, and I mean, I don't want to go into the details, but you can see in bold all the beautiful citations to the National Conference of State Legislatures, so I can't help point that out. Now, I'm just going to end up with some other interesting information about the United States judicial system. How many cases settle? Almost all of them do. When a case gets to the Supreme Court, it's pretty remarkable. When the case gets to any court, it's pretty remarkable. Criminal cases also settle probably at the highest percent. Why? Because litigation is expensive, it's time-consuming, there's always a chance that you'll lose. And something that was really emphasized to me when I was in law school is, if you have a continuing relationship and you have a lawsuit with someone that you have a continuing relationship with, it really kind of undermines your relationship. So most people just don't want to have lawsuits with people that they continue to be involved with. So what's the role of the Attorney General? The Attorney General is the chief legal officer of the state. Attorney General's roles are defined differently based on what is in the state statutes. They tend to bring civil cases on behalf of states. They represent the state and state agencies before the courts. They handle criminal appeals. In Wisconsin, all the criminal appeals are handled by the AG's office. They also do child support enforcement, consumer protections, antitrust. They enforce federal and state environmental laws. Sometimes there's tension between the state legislature and the Attorney General and the governor. Sometimes the Attorney Generals are appointed, sometimes they're elected. It all can be sort of a morass, but the Attorney General has a really big role. And some of these offices have hundreds of lawyers. You may wonder, well, where can I find the law? Traditionally, like Westlaw and Nexus are the best places to find the law, but they're both really expensive. If you're in your state capital, the State Law Library is a great place to find the law. Another thing is, it's sort of like reading Aristotle. Like, very few people read all of Aristotle. Instead, you read about Aristotle. And the law is kind of the same way. There's a lot of places to go where you can find summaries of the law, like treatises, restatements, law review articles. Those can be as relevant as anything else. And these days, to be honest, most of like state statutes are online, city codes are online. You can find almost anything that you want. There's also a couple of terms that people often ask me to define. And the one that I don't have on here that I use all the time is per curiam. So per curiam means unauthored. And sometimes the Supreme Court issues per curiam decisions where they don't have an author. But sometimes there'll be a dissent. So then you kind of know, who's probably in the per curiam majority, but you don't know who listed it. I also think that you don't have to, list your dissent. It gets all very, very complicated. Per curiam decisions are often heard without oral argument, but per curiam has nothing to do with oral argument. En banc. So remember how all the federal courts, there's the First Circuit, the Second Circuit, the Third Circuit. So if there's a case that's really important, a federal circuit court will hear it en banc. And what that means is every single judge in that federal circuit will hear it. When I was talking about that sexual orientation case, there's two federal circuits, the Second Circuit and the Seventh Circuit, who have said, we think Title VII protects people based on sexual orientation. Both of those cases were heard en banc. So every single judge heard the case and made a decision. Summary judgment. So this is a very this is a litigation term. It's kind of like the idea where a judge sort of, before going through a case in total, kind of takes a glance at the case and sees it's very obvious that one party should win. If it's very obvious that one party should win, before having a trial, before doing anything else, the court will simply say, I'm giving summary judgment to this side. It's very obvious that they should win. A preliminary injunction, you hear this term all the time. It's usually issued related to federal laws being declared unconstitutional. We've had a lot of preliminary injunctions about the travel ban, about sanctuary cities. A preliminary injunction is where someone rushes to the courthouse and says, court, we think this law is unconstitutional. And the court says, you know, I don't have time to figure out whether this law is unconstitutional. But at a glance, I'm going to look at the law really quickly. And I'm going to tell you off the top of my head if I think the law is unconstitutional or unlawful. And if I do, I'll issue one of these preliminary injunctions. And then you've got to keep on litigating the case. And when I get to look at it more carefully, I will decide to issue you a permanent injunction. So preliminary injunction is in a rush when there isn't a lot of time. You just want a court to quickly say, aha, I think this is unconstitutional. Qualified immunity. So my husband's a non-lawyer, and we've had 1,000 conversations about qualified immunity. This is a great place to end. So basically, state and local government officials cannot violate the constitutional rights of citizens per a law passed in the 1800s. But if those rights are not clearly established, they get qualified immunity, meaning they get immunity. So you're a government official, you cannot violate someone's constitutional rights. But let's say you do. If you do, and those rights were kind of murky, and it really wasn't clear whether you're violating rights or not until the judge looked at it, you're going to get qualified immunity. This issue comes up most frequently in cases involving the police shootings and the like, where, you know, someone will say this force was excessive, and the court might say, well, you know, maybe it was excessive, but at the time it wasn't clear to that officer that it was excessive. The court has taken, for the last couple of years, you know, this is a court that has like 65 some of the cases in the docket. It might take 5 or 6 qualified immunity cases. So I'm learning about them all the time. And so it's something I focus a lot on, and it's a very important immunity to state and local governments, and it's actually under attack by academics, which is another long story. So it's important that you know what it means if you're going to be like reading a lot about the Supreme Court. But the reality is it's still kind of a very narrow doctrine. Okay, so I think I got into the end. I'm going to see now if we have any questions. If you have a question, you can write it in the chat box. Okay, so someone writes, is precedent different than case law, or are they the same thing? They are the same thing. I probably shouldn't have used those words interchangeably, but they are used interchangeably. So that's a good question. Okay. Are state attorneys general considered executive or judicial branch? You know, that's a really interesting question. I would say I would consider them executive because they function more like an executive. But the problem is that oftentimes they're like elected separately. I think in most states they're elected separately. And the 2 states that I've lived in, and spent most of my life in Wisconsin and Virginia, they're elected separately. So they're often at odds with the governor. But they're not. The problem with attorney generals are not acting in a judicial capacity most of the time. There might be some instances where they are, but in general they're acting more in executive capacity. That's a really good question, and it's and my answer may not be entirely accurate. Maybe there's some sort of like third way to define attorneys general that I haven't really thought about. I'm certainly curious to hear how they would define themselves. Okay. You listed political questions as not being decided by courts. Oh, but didn't the Pennsylvania court rule recently on legislative districts? This is such a great question. So, yeah, so here's the deal. The Supreme Court is currently deciding whether or not partisan gerrymandering can be judiciable. I should back up and say 5 justices said it is judiciable. I have the worst time with that word, but I know you know what I mean. But there's never been a standard laid out for partisan gerrymandering or a coherent standard that 5 justices have agreed to. So this term the Supreme Court is deciding, in two cases, whether or not they can adopt this standard for partisan gerrymandering. And absolutely, historically, the court has looked at that, or some of the justices have looked at that as a political question, and by that meaning that it is the state legislature's responsibility to come up with state legislative districts. If they gerrymander, so be it. That's their prerogative. That's one view. That's the political thicket, political question view. The other view is like, look, after Baker versus Carr, after Reynolds versus Sims, we, the court, inserted ourselves in redistricting, and we're just going to keep on doing it. But the partisan gerrymandering question, what should be the standard, is the classic political question type question. And there are some justices that say, absolutely, this is a political question, we should run as far as we can from it, and other justices that say, look, these state legislatures are never going to take responsibility. All they're ever going to do is pursue their own interests, like Baker versus Carr, where the legislature hadn't redistricted for 60 years. That's what state legislatures will do. They'll become one side of the party, and that's all they'll pursue. And we, the courts, have to step in and handle it. I'm sorry, you shouldn't have asked that question, because I'm doing a presentation for New Jersey on it, and I'm just thinking a lot about that. So let's see. Any other questions? If not, I can turn it back over to Kay to close out the webinar.
Thank you, Lisa. This has been great. If any of you think of questions later, please just send me an email to kae.warnock, W-A-R-N-O-C-K, @ncsl.org, and I will connect you with Lisa. Thank you so much for attending our webinar. As a reminder, this will go up online so that you can share it with your colleagues in a few days. And thank you so much, Lisa. It's always a pleasure.
Thank you, Kay. Goodbye, everybody.
Thank you. This does conclude today's webinar. We thank you for your participation. You may now disconnect your lines at this time, and have a great day.